All right, well, it's 2:30, so we'll go ahead and get started with our introductions while a few other people join us. Hello, everyone, and welcome to today's webinar on COVID-19 legislative updates that employers need to know, Part 2. We are thrilled that you could join us for today's webinar, and we're going to go do our very best to make sure that we are giving you some timely information and we answer all of your questions. My name is Emily. I'm the Marketing Communications Specialist for Wagner CPAs, and I will be your moderator for today's presentation. I'm going to go over a few housekeeping items before we begin, and I turn it over to our two presenters. We have a lot of people joining us for our webinar, which is awesome, and we want to make sure that we answer all of your questions, but we also have our event run smoothly today. So for your questions, they'll be addressed throughout the presentation as they are submitted. Your questions can be submitted in a couple different ways. The first way is through the public chat feature, which is located at the bottom of your screen. These questions are general that may apply to many individuals on the call and will be discussed in the group. The second way to submit a question is through the Q&A feature, which is also located at the bottom of your screen. These questions might be more specific to you and your organization and will be addressed via email after the presentation. And I want to stress this, only questions that are submitted through the Q&A feature will be followed up via email afterwards. So if we don't get to it today, make sure you throw it in that Q&A button at the bottom and we'll email you with the response. Moving on, the PowerPoint slides and recording for today's webinar will be emailed to you after today's event. The webinar recording will also be available on our Wagner CPA's website within 3 business days under our recorded events section and our COVID-19 resources page. All attendees can view the recording free through the link that we send you, so you do have a couple different ways to see this information again. At this point, I would like to introduce our two experts who will be presenting today. We have Tracy Shirk and Brian Whitehead. Tracy is the founder of HR Foundation Courses and Shirk Consulting, a human resources consulting firm that provides authentic, innovative HR solutions. Tracy partners with small businesses in creating a strong and legally compliant HR infrastructure that is rooted in their mission. Tracy is married and a proud mother of 2 boys and 2 Newfoundlands. She has a passion for hiking and boating in the beautiful Wisconsin woods and living an authentic and purposeful life. Our second presenter today is Brian, and Brian is the partner at Nowland and Moet, I probably butchered that, I apologize, in Janesville, Wisconsin. A large part of his practice involves advising employers regarding employment law matters, including issues related to hiring, firing, policy development, and federal and state employment law compliance. So Tracy and Brian, take it away.
Emily, thanks so much for having us. And Brian, thanks for joining us today. I always love partnering with great employment lawyers, so it's one of my favorite things to do. So thanks for joining me today. And we're going to chat a little bit about coronavirus today. Are we excited? So with that, if you joined us on our webinar a couple weeks ago with Wagner, we went over some of the basics. We're going to very briefly touch on those today, but really what has changed with the 3 additional FAQs that came out from DOL. There's some additional items that came out from both OSHA and CDC, along with IRS. So that's really what we're going to be going over today. We definitely want to calm the crazy, because I think that there's times where we feel like we are in the middle of crazy. And so we hope that, by going through this webinar today and answering those questions, we can calm that a little bit, and maybe you'll even laugh a little bit along the way. When we first met last week, or a week and a half ago now, this is where we were at with COVID cases. And so we see, a week and a half ago, we were at 69,000 COVID cases. This was yesterday, where we were at 432 about. So there is some significant changes, and that's 1,000, by the way, that's not 100. I'll just clarify that. So we can see that this is continuing to become an issue, and with that, we are seeing the changes from the legislative side. So with that, we're going to go over, a brief overview of what the Family First Coronavirus Response Act is. And Brian, feel free to jump in at any point in time here. And I know you've got a couple key things that you're going to cover that I'm thrilled you're here with us today. And so just as a reminder, the emergency paid sick leave This is up to 80 hours of paid leave. Again, it's up to 80 hours, and there's 6 different reasons for that leave. And we'll go over in detail what those 6 reasons are and some of the specifics about how individuals qualify for those 6 reasons. Then we have the emergency paid FMLA. In the past, FMLA has never been paid. It has been a job protection. With this emergency paid FMLA, it's for one reason and one reason alone, and that's childcare. So just keep that in mind. The regular classic FMLA is still in place. That has not changed at all. So our emergency paid FMLA is for up to 12 weeks. And when we say that, that's including your regular FMLA. So if you've already taken 6 weeks in regular classic FMLA because you had knee surgery, then you'd only have 6 weeks under this emergency paid FMLA. Anything you want to add there, Brian?
Nope, you've got it so far.
All right. And so one thing to note here, weeks 1 and 2 are unpaid, okay? So you do not get paid for the first 2 weeks of emergency paid FMLA. However, you can take emergency paid sick leave under number 5 and get paid under the emergency paid sick leave. And then under the emergency paid FMLA, you're going to be paid for weeks 3 through 12. That is at 2/3 of your regular rate of pay, or up to $200 per day. And again, that's subject to caps, which is that $200 per day. Eileen asked a great question. Is the 12 weeks of FMLA in a 12-month period or a calendar year? So that's really going to depend upon how you have set up your FMLA inside of your organization, because you can set it up a couple different ways. It can be on a calendar year basis. It can be on a rolling 12-month basis. Those are the most common ones, but there's a couple others as well. All right, so let's chat a little bit more about the Emergency Family Medical Leave Expansion Act. So with that, who is covered on that is it's employees that have been employed for 30 days or more. So this is a really important distinction. The EFMLEA, you have the 30 days. The paid sick leave, there's not that 30-day requirement there, okay? So, and Brian, did you want to add something to the 30 days?
Yeah, it's one of the important things to remember there is the way that the Department of Labor is going to calculate that is the day that the leave would begin, they're going to look at the 30 days immediately preceding that. If the employee was employed for those 30 days, then the leave applies. I recently had a situation where an employer called. An employee had been laid off early in March. They were going to be recalled. The employee couldn't return because of one of the qualifying reasons under the FFCRA. And the question was, does the EFMLEA apply? The answer is no, because there was a gap in employment because of this layoff. We actually ended up going to the Department of Labor and discussing this with the Department of Labor. Department of Labor said that gap in employment actually precludes the employee from the emergency family medical leave.
Awesome, thank you. So again, who is covered? Employees who've been employed for 30 days or more, and as Brian kind of expounded on that a little bit. And who this applies to, again, the Family First Coronavirus Response Act applies to employers with 500 or less employees. This includes employers with 50 or less employees. We will talk about the small business exemption a little bit later on in our webinar today. And it's tricky, but we will talk about that a little bit later on. But again, it's 500 or less employees. If you were on our last webinar, we talked about how to do the math to get to 500. You can go back and watch that replay if you're on the cusp and you don't know how to do that. The other thing is the covered reasons. Again, these are for employees who are unable to work due to coronavirus. We have a lot of examples of this we're going to go over, but note, telework is really important here. If you can telework, if the employee can telework, we're going to have them telework versus provide them with the leave. So that's those conversations that we're having regarding that. Again, those benefits are available for 12 weeks. That protects their job. The first 10 days of the leave are unpaid. Again, it's 2/3 of their regular rate of pay, up to $200 per day. All right. And then we have the Emergency Paid Sick Leave Act. So this is our paid sick leave. These are the 10 days essentially for that. There's no 30-day requirement for this. So this is a key distinction between the FMLA and the sick leave. It's a maximum of 80 hours. So for example, you have an employee that works 50 hours a week. So their first week, they get paid the 50 hours of sick leave. That second week, they only get paid 30 hours because they've already reached that 80-hour max. So just note that that distinction is there. And then note that we'll talk a little bit about kind of the double dipping. So, hey, can we force them to take PTO first versus the employee emergency paid sick leave? What's important here is you're going to get the tax credit for that EPSLA. If you're going to get the tax credit, you're probably going to want to take that first. We'll talk about the documentation requirements for this and what IRS is requiring a little bit later on, and we kind of lay that out for you in a slide as well. Anything else you want to add there, Brian?
I'm just going to point out, so when you talk about the calculation of the hours there, using the 50 hours and the 30 hours, what we're looking at, what we're trying to determine with that is the rate of pay under the Fair Labor Standards Act. That's what we look at when we're doing that. So your example is exactly correct. So we would pay the 40 hours at the regular rate of pay, then 10 hours at our normal overtime rate, and then the following week we pay up to the cap. But the key question there is, what is the employer's or the employee's regular rate of pay under the Fair Labor Standards Act?
Yeah, and that's a great distinction because you're still going to pay them whatever that regular rate of pay is. And we've got an example coming up that actually does the math. I've had a lot of questions about, Tracy, I don't do story problems well, but I do math great. Can you give me a story problem? So we have a story problem coming up, okay? So again, this should be review if you've been on, a call with us, and just note that this is not easy stuff. This is really confusing. You may be asking the same question 6 times or watching 70 different webinars. I hope you're not watching 70, but trying to put these things together. So just note this is pretty complicated, and many of us that are consulting or legal, I know, Brian, you're probably looking at this, talking with your colleagues as well, going, okay, help us understand this. Oh, by the way, Brian, I can't give legal advice because I'm not a lawyer, but are you giving legal advice today?
No.
Okay. So if you need legal advice, please seek a lawyer that you're paying to do that. I can't give it. Brian's not giving it. So I just want to name that. So looking at our Emergency Paid Sick Leave Act, again, there's 6 reasons for that, okay? So those 6 reasons are the employee is subject to federal, state, local quarantine or isolation order. So one of the things that has changed from the last webinar that we did based on what the DOL FAQs came out with is that local quarantine order does qualify for number 1 here. But here's the distinction. If you are an essential employer, even though Wisconsin, because we're in Wisconsin right now, and I know you're all across the country, but Wisconsin is under a Safer at Home Act. So under that Safer at Home order, if you're an essential employer, you can still have your employees come to work because you are seen as an essential employer. Therefore, that individual is making the choice not to come to work even though work is available to them. So that would not be something that they could use if you are an essential employer and work is available to them, or you have telework available to them at home.
Another issue there that comes up, so Wisconsin's Safer at Home order went into effect, I believe, March 25th, which is prior to the date that the FFCRA became effective. So if a Wisconsin employer shut their business down because they weren't essential prior to the April 1st start date, this act does not reach back and pick up those employees. Those employees, if the business shut down because of a government order prior to April 1st, their remedy is through the unemployment process.
Yeah, and that's a really important distinction, right? If somebody is laid off or furloughed, they do not qualify for sick leave or this Emergency Family Medical Leave Act. You can't double dip. You're either taking unemployment or you have the potential to get one of these two benefits. The second one is a healthcare provider has advised the employee to self-quarantine. So with this is the healthcare provider advising that employee to self-quarantine. Something that just came out from the CDC yesterday is regarding essential employers. So if you are an essential employer, and I do have a slide on this a little bit later, and you'll be able to click the link to dig. But if you are an essential employer, and it had been that, hey, if you have been exposed to an individual with coronavirus, you needed to self-quarantine for 14 days. Now CDC is stating, nope, you don't have to self-quarantine as long as you are not showing symptoms. Brian, does this sound crazy to you?
It does. It's a change in the guidance that we've received prior.
Right. So just note that. So that is something new. Again, I've got a slide and a link later so you can find that. But again, a healthcare provider has advised the employee to self-quarantine. So somebody can't come to you and say, I'm self-quarantining because of XYZ. Your question to them is going to be, hey, Johnny, have you talked to your doctor about that yet? No, Tracy, I haven't. Okay, why don't you go talk to your doctor, come back to me, and let me know what that conversation is, right? So then we know that they've had that physician recommendation of that. Can we require a doctor's note right now? We can't require it, but we have to notate what that specifically is, and we will discuss that in a little bit. And then the third is the employees experiencing symptoms of COVID-19 and seeking a medical diagnosis. So they're having those specific symptoms that are outlined on the CDC website, and the medical diagnosis is stating, yes, you do need a self-quarantine or whatever that is. And this one is paid out at up to $511 per day. So this is the regular rate of pay up to the $511 a day. Anything on that, Brian, before we go to the other three?
No, ma'am.
All right. So the next three we have, there's a clear distinction here in that these are compensated at 2/3 of the regular rate of pay up to $200 a day. And so number 4 is they're caring for someone who's been advised of an order to quarantine. And I love that the DOL FAQ specifically stated that someone couldn't be an individual that you don't know. So I can't just state that I'm going to care for somebody that I met at a bar before this went into effect, right? Or whatnot. You actually have to know the person. So every now and then I think DOL does actually have some humor. So that's one, you have to know the person. And the key here is if you think about roommates, you're roommates with somebody, that roommate could be somebody that you would need to take care of because you're living with them. Number 5 is son or daughter whose school or place of care has closed. And so this is specifically looking at, yep, this is a place of care that has closed, even though they are in remote school right now, their physical location has closed, so that would count towards it. And then number 6, what does this mean? We don't know, and nothing has really been released on what this actually means for what number 6 is. So again, the first 3 are $511 a day. The second 3 are 2/3 up to $200 a day. I've been getting a lot of questions on intermittent leave. Can you take these items intermittently? The answer is yes, as long as it's not spreading the coronavirus, okay? So if you have the potential of spreading the coronavirus, no, you cannot take intermittent leave, meaning if you're physically going to an essential employer and you have, you're showing symptoms, no, you can't work intermittently. Now, even though you're showing symptoms to the coronavirus, could you telework? Because you're not around anyone else? Absolutely. So those are some things to keep in mind. So could you do this intermittently due to childcare, due to item number 5? Yes. All right. So we're going to get into some scenarios here in a minute. So again, these are the stay-at-home orders. I pulled this up earlier this week. So we're seeing most of the states now have stay-at-home orders. Again, that is in relation to item number 1. So let's talk about Katia. Katia is out or is requesting emergency paid sick leave. She's worked a variable schedule with multiple pay rates over the last 6 months. So the total hours that she's worked is 1,080, which ends up averaging, 40 hours a week, even though some weeks have been more, some weeks have been less. So she worked 560 hours at $15 an hour to give us a total of $8,400. She worked another 500 hours at 18 to give us $9,000. And I just realized that I needed to add, my hours are off a little bit here, but so we'll keep going with it. There's 60 hours at $20 an hour for 1,200. And then our shift diff is $2 an hour times 560 hours, which gives us $1,120. Brian, why did I include shift diff here?
You got me stumped. Go for it.
So I included shift diff in my non-discretionary bonuses because those need to count into my regular rate of pay.
It's a Fair Labor Standards Act question.
Yes, it is.
There you go.
There's my payroll background and my CPP certification coming out, that geekiness, right? So with that, what we're doing is we're taking the total dollars we have. So we have $20,220, right? We're dividing that by my 1,080. So my 20,220 divided by 1,080 equals 1872 an hour. And what that's giving me is my 1872 an hour. I'm going to take my 1872 an hour multiplied by 8 hours a day. Do we see what we're doing here? We're saying, 1080 divided out is going to give me my hourly rate over that 6 months. That's 8 hours. So my hourly rate's the 1872. I have my 8 hours a day, and that's going to give me my daily rate. Does that make sense for my folks that want story problems and want my one by one all the way through? The other thing I have on here is there's some links to the fact sheets. Fact sheets are fantastic when you're looking at this. I know that these calculations can be really tricky and you're kind of scratching your head, especially because the regulations state you need to go back and look at 6 months. And typically we're figuring this out in a work week and not looking at a total 6 month period. Anything else you wanted to add to regular rate, Brian?
Not to regular rate, but I want to step back just for a second to the intermittent leave question.
Yeah, I don't know.
So you're fine. You don't have to go back to this slide. I think
Okay.
it's fine. But we mentioned that yes, you can take this leave intermittently, provided that it's not for you're not at risk of spreading the coronavirus. One thing that the Department of Labor has done, I think, for employers here is the employer has the opportunity to agree to allow the employee to do that. This is very much a collaborative process. So I think the place where it makes the most sense to allow somebody to work intermittently is under that number 5 reason, right? They're providing some kind of childcare, especially if they can telework. So maybe they can work, 4 hours a day instead of their normal 8. And it's very easy to do that intermittently. I think it would be very difficult if we were under reason number 3, right? They're experiencing symptoms of COVID-19, especially if they can't telework, to say, yeah, we're going to allow you to kind of come in when you feel good and go home when you don't feel well. Obviously, that becomes very, very difficult. I think it's very important, especially for employers who are under 50 employees. You're probably not used to administering an FMLA policy, particularly if you're a very small employer. So it's probably much easier for you to just grant the leave until it's not needed anymore than to try to manage the intermittent part of that. But that is a calculation that you need to make with your professionals.
Yeah, and thank you for that, because there's a lot in the FAQs that specifically talk about, hey, this needs to be agreed upon by both the employer and the employee. Intermittent is one of them, and the other one is, adding on or topping off, what they call it, with topping off PTO time on top of your EPSL. So those are 2 areas where it has to be agreed upon by both sides. And we had some great questions come through. So if your regular rate of pay is the minimum wage, then you'd get 2/3 of the minimum wage for reasons 4 through 6. And that's correct. Another question was, lots of folks get raises in January. How does that impact your average? So how that impacts your average is if you, let me go back to that slide. You're essentially looking at your average by saying, hey, we have X number of hours at this pay rate, and we have X number of hours at this pay rate, and you're averaging them. So that's how you're looking at that, is you're averaging it based on the hours that they were actually paid and actually worked. Okay, so let's move on. There's a couple of exemptions here. We're not going to spend a ton of time on these exemptions, but there are some exemptions to this law, and these came out and were further clarified. So if you're an essential employer and you have these specific exemptions that fall under that, these are some great definitions. So healthcare providers, this is very, very generous, in my opinion, as to who is a healthcare provider. So just kind of read through that list. If that is something that pertains to you, then know that this law is exempt for those individuals. The next one is for emergency responders. Again, this law would be exempt for those individuals. They're saying, hey, these are essential to this, therefore, this does not apply to those individuals. The goal here is that we're providing services so that we can ensure that we can have individuals stay at home so we can take care of the health crisis. The next one that we have is specifically relating to small businesses. So we did have a question about, hey, our organization has only 5 employees. Are we going to have to pay the 12 weeks of sick pay at 2/3 rate if it will be economically hard for the organization? So here's the specifics on the small business exemption, and this is under 50 employees. Essentially, there's 3 kind of spokes to this. One is that individual must result in expenses and financial obligations exceeding the available business revenues, or it's about absence of employee or employees requesting paid sick leave are going to create a hardship for the organization, and that there's not sufficient workers who are able and willing to specifically work. But Brian, I know you had a little bit more to say about this one.
Yeah, to be honest, I think that this is a potential trap here for us. It is one of those that the way that it's drafted, there's certain things in the language that for me are just a little too spongy. It's a little too open to interpretation, right? At what point can we say that these obligations, the obligation to pay this leave will cause our business to cease operating? What are we going to have to show? What are we going to have to prove? I think it's a potential trap that we need to be very, very careful of. Another reason that I think we have to be very careful is the Department of Labor has not given us specific direction on what we're going to need to document to prove those things, what the standards are to prove any of these things. And so all they've essentially said is if this is a exemption that you want to try to claim, then you need to document your reasons that you think that this applies. You need to document who's requested the leave and why. And then basically we'll look at this when it's all said and done and make a decision. So this really puts the Department of Labor in the position of kind of playing armchair quarterback once we get through all of this to tell us if, yes, we did it right or no, we didn't. And that makes me a little uncomfortable for employers.
Great, thank you. Again, we have our notice of rights from the DOL. So just remember, this needed to be posted by April 1st. If you haven't posted this yet, please make sure that it is posted. You can email it, direct mail it, post a notice on the employee information intranet, whatever that is, but it's really important that this gets out there. And of course, OSHA had a couple things to say about this as well. And why is OSHA important here? OSHA is important because every employer falls under the general duty clause of OSHA. So if you are an essential employer, meaning, hey, you're having individuals still come into the work site, potentially being exposed to coronavirus, there's specific things that you need to do to take care of that. So these are 2 posters that OSHA came out with that are 10 steps all workplaces can take to reduce the risk of exposure, and then, hey, what are those individuals that have the highest risk? So these are things that are great to post and to share and ensure, hey, you're doing these things, like encouraging individuals to stay home if sick, making sure that you have masks and or the hand washing stations, etc. So just something to note specifically with that. Again, these were the 10 things that OSHA came out with, and ensuring that those are out there so that your staff specifically have them. Again, as we're relating back to this Families First Coronavirus Response Act, if you can show, hey, we've got these things in place, we're doing the best to take care of our staff, we're following through on what all these items are, what we don't want to have happen is somebody says, hey, I got sick at work, right? So those are some things to note there. I mentioned briefly earlier about the CDC and specifically relating to that number 2 item, where they've advised the employee to self-quarantine if they've been exposed to somebody specifically with coronavirus. This is what the CD says about it. Again, this just came out yesterday, so I wanted to make sure that you had this in your hands if that was something that was important to you. So are we ready to get into some specific scenarios, which is my best part, my favorite part of this? So we have an employee that has called in sick. What do you need to document, right? So the first thing we probably want to do is talk with the employee about why they're calling in sick. And again, we want to look at what are your attendance policies inside your organization. So are we still following a call-in procedure right now, or have we adopted something different based on this? And Brian, are you seeing that a lot of your clients have changed their attendance policy right now?
I'm seeing a lot more flexibility, just generally speaking right now. I think people are pretty sensitive to the situation. They're giving people a little more of the benefit of the doubt as we go along.
Yeah, absolutely. And I completely agree with that. And again, they call in sick, you need to document this. And, we definitely want to document those items under coronavirus that are specifically related to one of our six items. If they're calling in sick, it's probably going to be item number 2, right? We know that under the IRS regulations, in order to get the tax credit, we need to make sure we're documenting these items. So, here's an example. We're going to send an email to the employee recapping the conversation, because then guess what? We have a date and time stamp to show that it happened. What's the reason for their leave? How you've specifically calculated the leave. That's something that IRS is asking for. So when we look at that 2/3, how we're calculating it. So, what that regular rate is, we're requiring them to put the following in writing. Again, if you send them an email, they can just email you back and say, yep, we're good, right? That I agree that these were the key things. So these 4 items here are what is required. The employee's name, the date or dates for which leave is requested, a statement of the COVID-19 related reason that the employee is requesting leave and written support of such reason. This doesn't mean you have to have a doctor's note, right? So DOL is very clear on this, does not have to be a doctor's note. From everything I read in IRS, I think they would like it to be, but it doesn't necessarily have to be, right? It has to be something in writing. And again, when I look at this and say, do I want to pull a physician right now away from treating a COVID patient to fill out a form? I don't want to be that employer. I don't know, but at the same time, I know that I need to protect my employer to ensure that we have everything we need in order to get the tax credit. And then a statement that the employee is unable to work, including by means of teleworking, and what that specific reason is. And then as needed, we can share this with IRS and DOL. Again, tracking is incredibly, incredibly important. Do you have anything else to add there, Brian?
No, I think that pretty much covers the Department of Labor and the IRS's direction on this.
So there are a couple recommended policies and checklists. One of the key things is make sure you have a Family First Coronavirus policy. And if you have individuals teleworking, have a temporary teleworking policy. What are your requirements under this? One of the key things that I've been looking at and reading a ton about is relating to how are we going to track the time specifically for employees that are teleworking. So yes, this does become a Fair Labor Standards Act issue. And so make sure that you have that time tracking there. Make sure you're specifically state, you can't work outside of this specific hours or these specific items, so that you don't have an individual stating that they worked 60 hours a week when they only worked 30, right? So just make sure within your teleworking policy, you're really clear on what that means. And then some checklist tracking items, and I don't call these necessarily forms, because typically with forms, they have to be signed off, etc. We have this checklist to ensure that we're getting everything we need to get that tax credit, and to ensure we're being consistent with what our practices are. Again, the consistency is incredibly important, so that if anything does come back, you can show, yep, we were consistent with what we did all the way through. Our reasonable basis is we went back to DOL regulations, we went back to the temporary rule, to the IRS items, to follow what the law was as we knew it. So that's that emergency paid sick leave checklist, the Emergency Family Medical Leave Expansion Act checklist, and then a tracking form, so that we know, hey, we've got the tracking and it matches what we need, so that we can send that in as needed. These need to be kept for 4 years. So that's something that's really important, is we need to keep these items for 4 years, so the departments can go back and look at these later on. One of the things that I do want to note specifically on these is just ensure that you are not discriminating against a specific type of employee, whether it's age, whether it is based on a specific group. So we need to be really careful that, we are now past April 1st, meaning this law went into effect as of April 1st. So we can't now, say we're going to lay off all of the parents, all of the individuals that have kids, because we don't want to pay EFMLEA, right? That would be, discriminating. But not only that, you're going specifically against the law that's there. So anything you want to add there, Brian?
Well, first of all, I want to say, I think that you've given an excellent list here of just practical steps that employers can take. And I think that's one of the most important things to have, is just some practical planning in place. As it relates to, the policies that you develop and you implement, I think you do want to be careful to look at the effect of your policy across your employees. Smaller employees probably won't matter as much. Larger employers, it may have a more drastic effect. And if you find that the policy that you're implementing has the effect of eliminating a protected class of people from your workforce, I think that you're going to have to rework that policy and rethink that. Tracy mentioned that you want to be careful that you're not usurping the law. Right now, the DOL is not currently enforcing the FFCRA. There's a grace period, as it were, that's built into the law. That grace period expires next Friday. But that grace period only applies to employers that are actually trying to comply with the law, not avoid it. So if you're taking steps to avoid paying leave, you may find yourself painting yourself into a corner a little bit, and inviting some trouble from the Department of Labor.
Awesome, thanks. All right, so when we're looking at these, how we're developing the policies, and really what I mean by, when we're looking at this, start with the end in mind. So whether it's layoffs or furloughs, or hey, what do we need to do to reconfigure our staff, or hey, we're going to go ahead and we're going to take a PPP loan, we want to start with the end in mind here. So, some key questions that, just to really look at and to take into consideration are, what will our organizational structure look like when this is all over? What processes are going to need to be changed? I think many of us are seeing, hey, there's some things we're finding that we can be much more successful. And, you know, we had some huge holes in our system that now we're seeing with everyone virtual. So what are some of those key processes that we're going to need to change? And the need to change just based on how the marketplace is changing. And what do you want your employees to think and feel about you as an employer when this is all over? Do you want your employees to think, hey, this was a great employer, they took care of us during this crisis? Or, you know what, they were the quickest one to kick us out and say, go on unemployment, we don't want to have you here at all, right? So whatever that is, just kind of keep in mind what that will be at the end so that you know as you're planning this. And yes, hopefully we're halfway through this, but as we're working through the situation, how we treat our staff now will have an impact when we go to hire individuals back. We know what employment was previous to the pandemic. It was really difficult to hire great people. They weren't out there. So what will that be on the flip side of this so that we can be that employer of choice? Anything else you want to add to that, Brian?
No, ma'am.
All right, so unemployment. One of the key questions that I've been getting over and over and over, and there is a New York Times article there also. Wisconsin has some great information out there for unemployment, and most of the states do. Unemployment has been expanded significantly, but with that expansion to unemployment, what we're seeing that individuals that go on unemployment are getting the regular unemployment. They're also getting that additional $600 from the federal standpoint.
Mm-hmm.
So this is not a time to be ashamed to be on unemployment, right? This is not that time to be ashamed to be on unemployment because there are some keys there to help individuals to get by with that specifically. So just something to think about with that and how you're going ahead and laying off or furloughing your staff. One thing to look at also, many of the states have eliminated the work search requirements. Wisconsin is one of those. With the unemployment from the state perspective, a lot of the states have gone away with the 7-day wait. When I looked, I believe it was yesterday, I saw that Wisconsin still has that 7-day wait period because that's something that's specifically law, and that was on the unemployment website. So just know, hey, as you're rolling these out to the individuals inside your organization, be really clear on what those unemployment, what has changed with unemployment and how those benefits have changed in your specific state. So with furlough and layoff, and we did talk about this the last webinar we did with Wagner, so I just want to touch on it briefly. But the distinction between a furlough and a layoff is a furlough means you have the intention of bringing them back. A layoff essentially means that you don't have an intention of bringing them back. And as Brian pointed out, this is not a legal term, okay? It's not a legal term at all. However, that's really that definition is furlough, you have the intention. With furloughs, a lot of times you can keep paying for their health insurance. Again, you want to check with your health insurance provider to make sure that something crazy isn't written in the contract that you signed with them because the devil is in the details. So make sure you're looking at that. And then with a furlough, you don't need to pay out that accrued, but under PTO, if that's how your policy is written. With a layoff, you do. And again, layoff is a COBRA qualifying event. So you do need to kick out that COBRA paperwork right away. With furlough, you may, depending upon what your policy is and what your agreement with your healthcare provider is. Anything else you want to add on that one, Brian?
The one thing that I would point out is, as you referenced earlier, unemployment has been greatly expanded. And I think it's important to note that many of our employees may be better off in the short term to be able to take unemployment, especially if we're looking at having to dial back hours, things like that. Many of our employees may be better off to taking unemployment if we simply don't have the work to maintain our entire workforce.
You know, I got a really good question yesterday from one of my clients, and it was regarding, hey, we have an individual that hasn't worked for us for some time. They've been furloughed from their current employer, and so they're able and available to work. We want to hire them part-time. can we do that with them being furloughed from their current employer? And the answer to that question is one, yes, because they're not working for that. I would still check the furlough letter, but I mean, they're not working right now, so they're able and available to work. Now, will that impact their unemployment because they're earning? Absolutely. So those are some of the key things I've seen. Have you seen anything else come through with that, Brian?
No, not with that in particular. And I think your answer is exactly right. It will, if they're hired part-time, it would affect their unemployment. Depending on the type of employee this is and the specialized nature of their job, there may be an employment contract in place, some kind of non-compete or restrictive covenant that maybe you have to take into mind as well. And that could affect that analysis. But not knowing the specifics, it's hard to say whether that would in that situation.
Right. And that's something that's always important to ask is what else is around this, right? Like, hey, take a look at the furlough letter, take a look at those things. Is there anything here that's barring them from working? And that's good practice whenever you're hiring an employee, right? To know, hey, is there, do they have a non-compete clause or something else? That's just good practice to know those specific items. So let's take a look at a couple scenarios, which are my favorite. So Kari would like to work from home half-time due to childcare. Can she? Why don't you in the chat box just give me a yes or a no? Can she work from home half-time due to childcare? Or you can give me an it depends. All right, I am seeing some yeses. And they're still coming in. Up to employer. Okay. I'm seeing yeses up to employer. So, Brian, do you want to talk about the intermittent that we talked about earlier?
Yeah, well, I think first of all, we start with the question of why does she want to do this? Is her childcare provider unavailable, or is this a matter of this is just her preference, right? I think we have to look at that particular instance. If this is a school-age child, and it's as we are here in Wisconsin, schools are not meeting in a traditional sense. I think it's pretty easy to narrow that down. So then I think we also have to look at, does she have the ability to telework? If she can telework, can we work something out where she can continue to do her time? Look at those types of things. So there's lots of ways this can change and evolve. If it's a two-parent household and both parents are home, maybe dad is furloughed and not working at all. He's unemployed. Then there's not a need for Kari to be home. So there's a lot of this analysis that can go into this. So, and I see, and now I'm going to look at the slide now. So.
One of the things you just brought up, I think, is really important. So your employee must certify that no one else can care for that child. If you have, dad's furloughed, mom then does not have to take care of that child. That's one of the key distinctions that DOL has made. And so that's really important to know. The other distinction DOL made was if the child is over the age, is 14 or over, they can be by themselves at home as long as it's during daylight hours. If it's during nighttime hours, then it's up to 18. So, there's a lot to this, which is why we ask these, hypothetical asking for a friend questions. Did you have more to this one?
No, I think one of the things I think the Department of Labor did is it took some very broad statutory language and put some common sense parameters around it. You referenced the age limit on for the child. We talked about, is there somebody else that's available to take care of the child? Things like that. Because the statute as drafted basically says if the child's at home, then I should be able to stay home. But the Department of Labor put some common sense parameters on that, which I think makes a lot of sense.
Awesome. All right. So Jerry's showing symptoms. Can we send him home? What do you think? You can give me a yes or no in the box. Oh, I love these. Yes. Okay. But then can they work intermittently? My question is, do you have to pay him if you send him home? What are the symptoms? I love that, Jean. Thank you for asking that one. It depends. So again, if they're showing symptoms, do we want anyone in our workplace that has COVID or potentially has COVID? No, not at all, right? So we can send them home, but I would have a further conversation. Okay, maybe not a face-to-face conversation. Maybe I'm going to say, Jerry, go get in your car and I'm going to call you and we'll have a conversation. And my first question is going to be, Jerry, why don't you call your doctor, figure out what they want you to do with this, because they can then qualify under which number? It's going to be 2. Yes, it's going to be 2. Brian's getting my interactiveness that I love on webinars. You know, when you're an extrovert and you're working virtually, it's like you need as much interaction as possible.
I understand.
So yes, it's going to be under number 2. So we need to get some sort of, the information of who is his doctor, what's their address, what's their phone number. Did they advise Jerry to stay home? So that's what we need. So thank you for that. Let's go to our next one.
So let me push pause, because one of the answers there was, can they work intermittently? And because I think that response may refer to the prior question about Kari. I think the answer is yes. If you could work something out with Kari, with her children, if she had to stay home and work with her children, to provide intermittent leave on that. So I wanted to, just in case that's what that was referring to, I wanted to address that.
Awesome. But what about in this situation with Jerry? Could Jerry potentially work intermittently if it was telework?
If it was telework, potentially yes. Again, the question's really going to be Jerry's health.
Mm-hmm.
If Jerry is genuinely very, very ill and frankly unable to work, no, we don't want to put Jerry in that situation. If Jerry says, no, I'm fine, it's just a cold, doctor said I should stay home just in case, if he's able to telework, yeah, let's set him up and we can allow him to do that.
Awesome. All right. Can we require employees to have their temperature checked? What do you guys think? Yes or no in the box? Yes, we're seeing yeses. So we can require our employees to have their temperature checked. Do we have to pay them for that? Oh, I'm seeing a no. I'm wondering if that's regarding pay or if that's to have their temperature checked, or to pay them. So the answer here is typically no. You could not check an individual's temperature because that is seen as a medical screening. So the typical answer is no. However, we're not in typical times, are we, Brian?
We are not. We're actually being advised that this is something we should do.
Yes, we are. So we're being advised that this is something that we should do. And yes, you want to pay them for it. Okay. Anybody remember the donning and doffing rules and regulations a couple of years ago? Hello. Yes, let's pay them for it. And it's just the right thing to do. Let's not be like creepy, sneezy employer. Okay. Let's make sure we're paying them for it. So do we need to, what about HIPAA here? Do we need to ensure that we're not sharing that information? Absolutely. We're not going to go say, hey, Brian has COVID. No, we're not going to do that, right? So we do need to make sure that we're being careful with that. But yes, we can absolutely check their temperature. Also, I refer to the new CDC guidance earlier in our presentation today. They specifically state that if somebody has been exposed to an individual with COVID and they fall under one of the 16, items or required industries, yes, they can still work, but they have to have their temperature taken before they come to work every time. So just specifically note that, yes, we can do temperature checks, and yes, we need to pay them.
So Tracy, can I ask a question here? Because I have not seen guidance on this, and I'm wondering if you have. Is there guidance on who can take the temperature?
I have not seen that guidance, and that's a really great one. I have not seen that guidance at all.
Okay, it might be something for us to look into down the road, because I can see, because we are dealing with some HIPAA related issues, we want to limit who can do that. probably best case scenario right now is whoever handles your HR is probably the people that you want doing that in this particular instance until we have further guidance.
Yeah, I did see guidance specifically on how you take the temperature. So for example, you want to do it with like the little gun thing.
Mm-hmm.
You don't want to stick, thermometers under an individual's tongue.
In general, you don't want to make contact, right? Because
Exactly.
we have the infrared, those types of things. I just think that information could be, because it ties back to HIPAA, I think the question of who does that is also important. So.
Yeah, absolutely. All right. Your employee Johnny does not have symptoms of COVID, but insists that he needs to take off work to avoid any exposure. Is he eligible to take emergency paid sick leave? What do you guys think? I am seeing a lot of no's. Brian, what do you think?
I think it depends. Johnny can't self-select into this group, but
Right.
he can consult a physician. And if that physician tells him that it is in his best interest to quarantine or to self-isolate, now he's given. Now he falls within that second reason for the emergency paid sick leave, and so he can take that emergency. He can request and receive that leave, but it really is a question of, has he been advised by a healthcare provider to do that? Or is he self-selecting into that? He can't just wake up, I don't want to go to work today. You know what? I'm going to request leave. It doesn't work that way. He has to have a verified medical reason for that.
Right. And so this kind of follow-up question is, do you need a leave request form? So again, right, we're not necessarily using forms for this. We're doing everything via email so that we can get that written documentation of that. But let's say that, you tell Johnny he has to specifically have, that physician recommendation to do that. He disputes it. And comes back and says whatnot. So make sure you're still documenting all these things. I know for my clients, I created an Excel spreadsheet for them that specifically had the tracking for their EPSL and EFMLEA. It specifically had a checklist for me that helped me to ensure that I had all the required items. And then it also has a log on it so that I am logging every conversation that we're having with staff, so that, hey, if something ever comes back, here's what we did, here's what they said. Remember that DOL states if it's not in writing, it didn't happen. We want to make sure that we have this stuff in writing because, at the end of this, are you going to remember the 557 requests that you got? No, probably not. All right, let's move on to the next one. I think we have two more. So can you require employees to take their PTO time with their employee paid sick leave? Yes or no? What are your thoughts in the box? And we did pretty much answer this one earlier in our presentation. I am seeing lots of no's. And so this is where it was talking earlier about how, unless both the employee and the employer agree. So it's called topping off is what they called it actually in the regulations. I also saw one come through, yes, if before 4/1. Thank you for that. Because again, these regulations went into place on April 1st. So April 1st is when these went into place. So that's something really important to note is, hey, they went into place April 1st. Anything before April 1st was based on the regulations that were currently in effect. So one last one, and this is James is taking the emergency FMLA leave. So he's using it intermittently, and can they use it over a longer period of time than 12 weeks? So here's the deal with 12 weeks. When you use intermittent FMLA, it's based on the hours that they typically work, right? So intermittent FMLA has some very specific guidelines to it. So there's a number of fact sheets out on the DOL website regarding intermittent FMLA. So you're going to want to kind of revert back to those previous guidance. Do you have anything else on that one, Brian?
No.
So there's an example here, and this I had requested if you had questions beforehand, so a lot of these came from those questions that came in before our webinar today. If James is working 2 hours a day and using 6 hours of leave, during the 12 weeks, he would use only 75% of the hours. Again, it's looking at, you can do intermittent, but remember the max pay here is $10,000, okay? So you have a max of $10,000 for that. The other $2,000 is under the EP, emergency paid sick leave, EPSL. So you only have $10,000 to play with under that emergency FFCRA. All right, that is all of the questions that I had that came in before. And I think we've answered most of the questions that have come through. If we didn't get your question, please, please, please make sure that you retype it in the Q&A box. That way, Brian and I can respond back to those and make sure that you get those answers. So again, that Q&A box is going to be your golden ticket. Again, the world's sick right now, but we're going to get better. So, we just want to know that, hey, there is another side to this, and how do we want ourselves to come out on that other side? So I believe we covered all of our what if examples. You will get our slide deck afterwards. We have lots and lots of resources here. OSHA came out with a ton of them. Feel free to contact myself or Brian with any questions. Our numbers and our emails are up on the screen. We're happy to answer your questions, and thank you so much for being here with us today. And thank you, Brian and Emily.
Yes, thank you so much, Tracy and Brian, for your time and expertise. And everybody who joined us today, like Tracy said, please submit your questions in that Q&A box, and we'll make sure to reach out afterwards with those answers. If you don't have any more questions today, thank you again for joining us, and keep an eye out for an email from us with the link and the presentation from today. Have a wonderful weekend.